This video is made for educational purposes only and cannot be taken as legal advice. This judgment just goes to show that the police have no understanding of the law they are sworn to uphold. In this video we are going to take a look at a Court of Appeal judgment concerning assault of a police officer whilst executing his duties. Collins v. Wilcock, QBD 1984. The defendant appealed against her conviction for assaulting a police constable in the execution of his duty. He had sought to caution her with regard to activity as a prostitute. The 1959 Act gave no power to detain. But he took hold of her. She resisted, and injured him. The court held, there was no arrest, and no power implied or otherwise to arrest. The attempted restraint was therefore itself an unlawful assault, and she was entitled to resist, and the conviction was quashed. Battery involves a. touching of the person with what is sometimes called hostile intent, as opposed to a friendly pat on the back, meaning any intentional physical contact which was not generally acceptable in the ordinary conduct of daily life. The tort of assault is an act which causes another person to apprehend the infliction of immediate, unlawful, force on his person. False imprisonment is the unlawful imposition of constraint on another's freedom of movement from a particular place. Robert Goff LJ said, a broader exception has been created to allow for the exigencies of everyday life. Generally speaking, consent is a defense to battery, and most of the physical contacts of ordinary life are not actionable because they are impliedly consented to by all who move in society and so expose themselves to the risk of bodily contact. Although such cases are regarded as examples of implied consent, it is more common nowadays to treat them as falling within a general exception embracing all physical contact which is generally acceptable in the ordinary conduct of daily life. We think that nowadays it is more realistic, and indeed more accurate, to state the broad underlying principle, subject to the broad exception. In each case, the test must be whether the physical contact so persisted in has in the circumstances gone beyond generally acceptable standards of conduct, and the answer to that question will depend upon the facts of the particular case. But, if a police officer, not exercising his power of arrest, nevertheless reinforces his request with the actual use of force, or with the threat, actual or implicit, to use force if the other person does not comply, then his act in thereby detaining the other person will be unlawful. Robert Goff LJ. Conviction quashed.